Do I really need an attorney when going through probate in Florida? Or is this something I can handle on my own? Or if I do need an attorney, when is it actually required by law versus strongly recommended? So in this video, I'm going to explain when Florida law requires probate attorney and when there's some flexibility and why having the right guidance often saves families time, stress, and costly mistakes during what there is already known as an emotional season. Before we get into the details, let me just say, if you're watching this because you've lost someone recently, I'm truly sorry for your loss. Probate is not something that most people ever expect to deal with, and yet you're trying to do it and doing the right thing for your family while grieving at the same time. For a comprehensive list of everything you need to know about probate, click the link in the description. So let's talk about this in a clear, calm way. In most Florida probate cases, the answer is yes, an attorney is required. Florida law generally requires that a personal representative, also called an executor, be represented by the probate attorney when the estate goes through the formal administration. Formal administration is the most common type of probate, especially when there's a home involved, multiple heirs, or when there are significant assets. This requirement is not meant to make the process harder or more expensive, but rather ensure that strict rules, deadlines, creditor notices, and court filings are handled correctly according to Florida law. Now, there are limited situations where an attorney may not be legally required. For example, some estates qualify for summary administration, which is typically used when probate assets are lower in value or when a person has been deceased for more than 2 years. In those cases, the court may allow the process to move forward without an attorney. There's also something called disposition without administration, which applies only to very small estates with minimal assets. These cases usually do not require a lawyer, but here's the thing, I want you to hear very clearly. Those situations are the exception and not the rule. Most Florida estates, especially those involving real estate, end up in formal probate. Once you are there, an attorney is not only optional, but it's required. Even when an attorney is not technically required, many families still choose to work with one because probate is not just paperwork, it's a legal process with real financial consequences. Mistakes can lead to delays, disputes, unnecessary expenses. I've seen families start probate thinking that they'll save money by doing it themselves and run into all kinds of issues and end up costing them far more time and stress and frustration. This becomes especially important when a home is part of the estate because selling a property during probate involves specific rules, timing and considerations, and sometimes court approval. When the legal side and the real estate side are not aligned, things can slow down quickly. That is why I often work alongside probate attorneys to help families understand how the home fits into the process, when it can be sold, and how the proceeds are handled so there's no other surprises. So if you're wondering whether you need a probate attorney, the real first question is what type of probate applies to your situation? Because that answer determines all legal requirements and your next steps. If you're feeling a little overwhelmed right now, please know that this is completely normal. My role is to help bring clarity, reduce stress, and guide families forward with confidence during this time of need. If you have any questions, you can always call me for a free consultation, no obligation, at 904-544-5252.